Now I'll talk about my presentation. This is one that it's somewhat, I guess, rudimentary. So I welcome if you have any questions or thoughts along the way, you can feel free to kind of make it interactive with me. What this presentation really is sort of some of the questions that I have to look up or research. Sometimes I just forget what I knew a year ago and I have to keep looking something up, and points that I think are important to keep in the front of your mind, particularly if you don't do a ton of maritime work. So I'm also going to try to incorporate some interesting cases so that we can keep the dialogue going there. But to begin, what I always like to tell people who are taking on maybe one of their first maritime cases is to figure out what exactly is maritime law, because it's somewhat different, right, than our state court cases. And we all know the case law essentially says that it is a mixture, an amalgamation of federal legislation, federal common law, and state maritime law. And what I really like about our little community here is, first, I like the people. I think that practicing maritime law, you're with typically high-level attorneys that really care. I think everyone is passionate about this stuff that's involved and wants to grow and expand. And I like that it's an interesting body of law, and it allows for some pretty serious creativity when you're handling a case. And you can kind of use all the different statutes, the common law, and supplement with non-contradictory state court law to the extent it applies. So when you're starting off, I think it's important to know there's a mixture of different areas you can derive from to really bring forward a strong case on your client's behalf. Some of the preliminary considerations that I think practitioners should go through is obviously what law applies. For most of us, that's going to be pretty immediately apparent and not a big question. But sometimes it could be some gray area, whether or not maritime law, state court, tort law will apply, and why does it matter? And this is a question that I seem to hear a lot and get a lot from people that are going to take on a maritime case and don't do a ton of it. So I think it's a good time just to refresh what the elements are and kind of think about it and think about updates as well. So the classic test, a party seeking to invoke federal jurisdiction over a tort claim in Admiralty must satisfy location and connection with maritime activity. That's sort of the benchmark that everyone has memorized back from either maritime class or when you first started practicing in this area. But then it gets a bit more granular. So the location test, to me, seems to be where most of the case law and the developments arise. And essentially what must occur is that the court needs to determine whether the tort occurred on navigable water. Seems kind of self-explanatory and basic, right? Navigable water, in my mind, just hearing the term would mean any water you can travel on. But it's actually a bit more granular than that, and we're going to discuss why. The other test that needs to be met to invoke Admiralty jurisdiction is the connection test. And that's going to raise two issues. First, whether the incident has a potentially disruptive impact on maritime commerce. And second, whether the general character of the activity shows a substantial relationship to traditional maritime activity. I can't really think of a case where this part of the test has not been met. It seems like almost anything will be found to have that disruptive impact. And I feel like most of the case law that I've seen or where it's been important to analyze has been on the location and its importance on the law that will apply. So for the court to have jurisdiction, the body of water obviously must be navigable. And the applicable test for determining that is whether it is capable of supporting commercial activity. And sort of the marquee case that I first remember coming across when I was looking into how all this worked back in the day was this case, Tunador versus Miami-Dade County, which I always thought was an interesting case. It kind of stuck in my mind. So for those of you that are South Florida folks, we're crisscrossed down here with different canals and small waterways. And sometimes people go out there and something happens. I think in the Tunador case, if I recall, they drove into like a low-hanging bridge or a pipe. And there was a pretty detailed and interesting analysis. I've read the opinion a few times over the years and how the court arrived at their decision and what they did. And in fact, I think one of the employees for the county even took a little canoe and did a video showing the path of the canal and the different obstacles that were in the way and where it was, too shallow for any sort of actual vessel to move through. And the analysis essentially said that simply that Miami-Dade County Canal was simply not a navigable waterway upon which to claim federal admiralty jurisdiction, where the canal had a series of control gates, culverts, pump stations, pipes, and low clearance bridges. So I thought this was pretty unique because it was a canal, if memory serves, that was connected to larger waterways, but it still did not meet that standard of navigability. So in this case, federal maritime and admiralty law did not apply. It was Florida state court law that was going to apply. And a key quote that I pulled from this case was that navigability does not require that a waterway be currently used in commercial activity, but it does require that a waterway be capable in its present state of supporting commercial activity in order to promote maritime commerce. And I thought this was pretty interesting and unique. And I looked into a few other cases from other states, and there are situations, for example, where there might be some sort of a dam or a lock that's erected, and there's an issue that it could later be removed and the waterway would again become navigable. And if that's the case, then it will be triggered. But in a case where it simply will not support commercial activity, your state court law is going to apply. So some people that don't do a ton of maritime law might be wondering, well, why does that even matter? Why is that important? And we're going to get to that after we consider a few more factual patterns. What about an incident on land, at a marina, or at a dock? We hear about these types of cases all the time where maybe a crew member gets hurt or something bad happens where a vessel is damaged at a dock on the land. And there's actually a pretty substantial body of law on this that shows that the boat must actually be in the navigable water. So if it's on dry land, it's not going to fall under general maritime law. However, interestingly enough, if it's in a dry dock, that is considered navigable waters. So essentially, you need to kind of look this up if you're somewhat concerned and double check on the law. But a dry dock would be considered navigable on the land, up on blocks, whatever it might be, in a marina. That's not going to be maritime law, maritime jurisdiction. Another one that I was thinking about, which in my mind kind of jives with the analysis for Death on the High Seas Act, is what about a case involving products liability or negligence that occurs on land, like some of the common jet ski products liability cases, or something that goes wrong because a component part is defective. Seems to me if the tort arises because the manufacture occurred on land, it might be a good argument that you could apply regular state court law. But there's a clarification, and I cite the case from the 3rd DCA, that the case is clearly established that an accident like this, products liability involving a jet ski, which causes a serious injury to an occupant of a seagoing craft, even if no other vessel is involved and the defendant's alleged negligence occurs on land, qualifies under the definition, and it'll trigger maritime law. So it might not be quite so readily apparent. And I think it's sort of unique how these different cases will come to play. And you'll see that sort of the confluence of different areas of law, products liability, and our maritime law, and sort of seeing how you can supplement with your state court claims into the body of federal common law that is maritime law. From a practical standpoint, someone that is looking at maybe one of their first maritime cases might be wondering, why is this so important? I'll just look up the law and figure it out. But it can actually have a dispositive impact if you're not careful. So obviously, this is even more important now with the recent HB 837 law changes for the personal injury practitioners. But you're going to have a different statute of limitations depending on whether or not potentially it's state court tort law, maritime law, or maybe even something special that arises in a contract. So there's a handful of cases where people didn't figure that out at the front end and they missed a statute of limitations. For instance, the cited case here is Briggs versus Jupiter Hills Lighthouse Marina, and it talks about the application of the Admiralty jurisdiction for the 3-year statute of limitations back when Florida had our 4-year statute for torts. So be careful. No one wants to get in a position where they've missed a statute of limitations. It's an easy thing to not screw up, but it's rather complicated if you don't do this with some regularity. We all know that there is a statute right on point that gives us a 3-year statute of limitations in the federal books on maritime claims. And, if you're not doing a lot of this, you might not realize particular cases such as the cruise lines when you agree to go on a cruise, you're going to get a contract that sets forth you have a 1-year statute. So it's something to keep in mind, something a little bit special, and you might not even realize that this is happening if you're not kind of versed in this area of the law. God bless you. All right, next up. So here's another practice point that I kind of think is interesting. If Admiralty law is going to apply, the standard of care pretty typically is going to be reasonable care under the circumstances. But in Florida, we have a special set of statutes, as most of you all know, as Admiralty practitioners, that apply to our waters. And I thought this one is kind of interesting in a case where Admiralty law might not be triggered or isn't triggered. You can argue for the highest degree of care to prevent injuries. So I'm always looking if I can make this work. And, the case law is pretty clear, and especially in the 11th, about reasonable care under the circumstances for cruise line cases and for other maritime cases. But if you have something that is in sole state waters and you can get state law to apply, then obviously this could be a powerful tool for a plaintiff and something important for a defense attorney to know to advise their client. And there's a 5th DCA site where this was analyzed in the case of Bradley versus Guy. Obviously, another key initial consideration that you're going to have to think about is your right to a jury trial and what might trigger it or what might not trigger it. So typically speaking, in the cruise line context, we're going to file all those cases in the Southern District or the Middle District or maybe somewhere out in California or the Western District of Washington. But if it is a case that isn't subject to some sort of a contractual forum and venue selection, the plaintiff is going to be able to decide if they want to file in state court or in federal court, and both courts will have diversity under the savings to suitors clause. The benefit to filing for a plaintiff perhaps in state court would be that under our Constitution, you have that right to a jury trial, whereas if only Admiralty jurisdiction is triggered, then the federal court will not automatically give you that jury trial. Oftentimes you can ask for it, and the parties, particularly in the cruise context, there's not going to be a fight on that. But I've seen some judges that aren't willing and they want to know. So you need to set forth, if you have diversity jurisdiction, I would say set that forth. And just keep in mind, depending on where you decide to file your lawsuit or if you want to remove it, it might have implications on whether or not you're going to get that jury trial. So to wrap up the section a little bit here on application of the law and some initial considerations, keep in mind that federal and state courts must apply maritime law that directly addresses the issues at hand. And again, that's going to be derived from your federal statutes, the common law, and then non-contradictory state law. And the maritime law can be supplemented and modified by the states where the supplement or modification does not conflict with an essential feature of maritime law or federal legislation. So that's going to allow you to be much more creative. Like I mentioned at the onset, if you can try to figure out a way to get some of your more unique state court law to apply, it's often beneficial, and you can sort of make beneficial changes in the law if you do it right. So part of the reason why I think so many of us are passionate about this area. Who is responsible? So an important consideration, obviously, and I think maritime law maybe lends itself to finding more theories of responsibility, finding more theories of liability, and potentially considering if you want to expand who you're going to sue and different ways to potentially defend the case. There's a long list of considerations that at first blush, it might not be so simple, but especially as technology advances and the industry grows, I think that the types of claims that can be brought, the different defendants available, and the different potential counterclaims, there's a lot of them, and it's always changing. Going to play a small video here and sort of move into the next section, so bear with me. This is from a case that is currently active, and this was in the news, but this is my client, and it's showing that's right behind government's cut there down here in Miami. So yeah, pretty obvious what happened there. But I think it kind of underscores that oftentimes in these types of cases, there might be a lot of different people involved and a lot of different theories of liability that you can think of when you're building and putting together your case. So for instance, some common negligence theories would be the obvious one, a collision or an elision, failure to follow what I'm going to call the rules of the road, which is the inland navigation, which are pretty easy to understand. And if there is a complexity, there's a lot of great experts out there you can work with that will help get you in the right direction. FWC, they have their own navigation rules in some circumstances, and a lot of the counties, particularly pertaining to the intercoastal, will have different wake violation rules and speed rules, and it could even vary on the time of year. So it's something to dig into and to check out when you're putting a case together. Obviously, there's tons of cases involving propeller incidents, wake incidents. The next one on the list, bow riding, is a big thing that I've seen lately, both in the Coast Guard's targets, in their crosshairs, and also it's really common now if you get on some of the Instagram accounts like Qualified Captain, they kind of point out dangerous things that people are doing, and you see this all over the place with children and with people that are just hanging off the front of a boat, and it's super, super dangerous. I want to say that I've read recently somewhere that the Coast Guard is either suggesting or might have even made a change, it might be in case law, and I'll figure that out, that this kind of conduct is going to be per se negligent or perhaps even higher than that. So, it's a serious consideration. And if you get on Instagram now, you'll see kind of a shaming for it, which I guess is good from a safety standpoint, helps people maybe be more conscientious. Obviously, unseaworthy vessel kind of walks hand in hand with negligence, and then lack of proper safety equipment on board. Things such as an inadequate number of life jackets for passengers, overcrowding the vessel beyond safe capacity, boating under the influence. So for obvious reasons, it's a big no-no and a fact that no one wants to see happen. I think a lot of people that don't do a lot of boating that come down to Florida on vacation, also, they don't even realize, in addition to taking it out of the tort context, from the criminal context, how serious FWC is about sort of patrolling for it. And I think a lot of people, when they go out on a boat, they think it's like a car where you have to have some sort of a reasonable suspicion or probable cause. They don't realize that FWC and the Coast Guard can just come on your boat to do a safety check and end up getting themselves in trouble. So another common theory is obviously embarkation and debarkation incidents, and then recreational incidents, jet skiing, parasailing, skiing behind the boat, being in a tube. We're seeing a high prevalence of this. And a lot of it kind of, I think, is arising because people aren't really adequately trained on the safety and what it takes to safely operate a vessel. And it's very common. These are kind of the basic sort of theories you can think of if you're working through one of your first type of maritime cases, or even if you're just trying to get out of a rut and think more creatively and come up with a way to do something outside of the box and moving forward or defending a claim. Like I mentioned before, the inland rules, these are, they're going to apply to almost any body of water where you can navigate a vessel here in the United States. And they're pretty straightforward. And a violation of them, in my mind, is negligence per se. It's pretty obvious. I like to take a look at all these when I start any sort of case where it will apply. And you can see some of the things such as failing to maintain a proper lookout, failing to proceed at a safe speed, using all available means to avoid a collision or determine if one could exist. And then there's even under Rule 2, I think, just a general rule of good seamanship, which in my mind almost seems to be a violation if you operate a vessel negligently. So these inland navigation rules can be a big tool. And obviously, I think if you're dealing with some sort of a collision case, there's going to be a counterclaim. And even if your operator, if you're defending it, if your owner or operator is alleged to be at fault, perhaps the other driver also didn't follow one of these. And it's something to consider. Interestingly enough, here in Florida, we have a statutory duty to comply with the inland rules. I cite it here for you all, 327.33 sub 3. And again, I think when you're starting out to take on one of these cases or some of the first steps, I usually, even though I do a fair amount of this, will re-review the statutes. There's obviously our Florida stuff, and then we have a federal counterpart of rules and regulations and laws that's going to also apply. They're fairly similar, and I usually like to look into both and kind of figure out what's happening under both so that I can see all the moving parts in a case. And it's important to know that there's actually a statutory duty here in Florida that sets forth that those rules are going to apply. Similarly, you have the Pennsylvania rule, which is an antiquated old rule, but it basically is a burden shifting when a collision occurs. And there's some interesting case law that's been developing on this rule in the last few years and probably the last decade as to when it will kick in and apply. But essentially, when the court applies the Pennsylvania rule, where a defendant violated statutory rules intended to prevent boat collisions, the court presumes that the defendant's fault caused the collision, and then the burden will go ahead and shift to the defendant to show that the violation could not have caused the accident. Very important, very useful, very powerful. The operative word that I want to draw to your attention in that cite from the Matter of Chavez case is the word collision. There's been throughout the different states a handful of distinctions in the case law when plaintiffs, I guess, or sometimes will argue that this should apply, and the court, how it defines collision versus elision versus some other sort of an incident. And it's sort of narrowing it down that I think it has to almost be a collision for the Pennsylvania rule to apply. Collision obviously is two boats hitting each other, two vessels hitting each other, and then elision technically is a fixed object or some other object, a navigational beacon. So there's actually a difference, even though the two terms sometimes get used interchangeably. Our livery statute theories here in Florida. This is something to always check out and to be aware of if you're counseling someone that's going to run some sort of a boat rental operation, or you have a case where someone gets hurt out on a rental vessel. This is a call we get all the time, is that people will rent a boat. They're not told what to do. They've never really been on a boat. They don't understand the danger of allowing someone to swim near a propeller while it's running, even though that seems like, oh my God, so obvious. You know, it's a case that we get calls about all the time. I think it's probably something that if you are going to run an operation, you should take very seriously. It doesn't seem to be super hard to do. But, you know, these things happen, and it's kind of shocking that people will get behind the wheel of a boat when they have no clue what they're doing. So that's all I want to say about the livery statute. I'm sure you all are familiar with it. I want to change now to some common defenses and just sort of go through the ones that I tend to get a lot of questions about and tend to have to look up with some regularity as I'm moving forward over the years on a case. So to start, I'm going to talk about the limitation of liability action, which is a changing topic, and I would say kind of a hot topic lately, specifically with one of the changes that arose within the last few years as a result of that horrible fire off the coast of California, the diving ship, the Conception. So, you know, that was a awful case. And what happened there, it's my understanding that that there was an issue with charging of cell phones, or some sort of an issue with batteries and perhaps a defective type plug. And the day before the fire occurred, one of the crew members tried to charge their iPhone, and they might have noticed an issue and didn't really do anything about it. 24 hours or so later, the boat catches on fire. And most of this, I'm obviously just saying what I've read, but it's my understanding that the boat catches on fire. The captain doesn't make a call over the intercom to wake everyone up. The captain kind of jumped ship pretty early, even though there's some firefighting extinguishers near him and an axe near him. I think some of the passengers below, the 34 or 35 passengers below and some crew, they even noticed the smoke starting to billow, and they took video of it, which the NTSB was able to recover. And it just, things moved quickly. The captain and the crew weren't really given, the captain didn't give the crew many directions on how to life save. It turns out there hadn't been training on how to save people's lives in the event of a fire. All of the crew, and this I thought was kind of shocking, all of the crew, and there were 6 or 7 of them, were asleep at the same time, so they didn't catch the fire early enough. And the Conception, this fire just raged, and I think 36 or 37 people, maybe a little less, lost their lives as a result. and it prompted a limitation action. And that was very, I guess you could say, concerning to some of the California lawmakers who proposed a change in the law and limitation of liability, which was ultimately successful a few years back and narrowed the field of what will apply under a limitation action. So now it's been changed that it no longer, it shall not apply, to covered small passenger vessels. And what does that mean? So essentially a small passenger vessel, which is also defined under sub 47, is carrying more than 6 passengers, including at least 1 passenger for hire. So as a result of amendments to the Inhofe National Defense Authorization Act, which was prompted by the Conception fire, now there is a class of vessels that you can no longer claim a limitation or exoneration for under 46 USC 30502. So, I think my understanding, this law originally came about hundreds of years ago, sort of in Europe, and when they were trying to promote people to manufacture vessels and engage in seafaring activity. It seems, at least I think, somewhat antiquated to a certain extent and unnecessary in light of the common prevalence of the insurance industry and the sophistication of vessel owners, manufacturers, and the seafaring industry. So this is a small change, and I'm curious to see if maybe similar laws like the Death on the High Seas Act, which might have served a purpose 100, 150 years ago, are going to start to change as well, with the prevalence of cases like the Conception being more known in the media and things of that nature. So that was an interesting, horribly tragic case, and it seemed to have prompted this change. So now keep that in mind. If you're defending a case or bringing a plaintiff case, you may well have a motion to dismiss limitation action if you weren't up to speed on this change. The next topic, which is quite common in most of the cases, particularly dealing with recreational type fact patterns, is a waiver. So I think we all know in the cruise industry, waivers will not be upheld. That's codified under 46 USC 30509. Essentially, under that law, if a vessel is hitting a U.S. port, there cannot be a waiver or a limitation of liability, or an agreement to arbitrate or have someone sign away a right to a jury trial. There is interesting case law on this. It basically is from ports in the United States, and ports is an important word. It ends in an S, so it's not one port out and one port back. It's ports, or a port in the U.S. and a foreign port. And there's a recent case I read out of Hawaii where there was an argument that this should apply to a vessel that came and went from the same port, from the same location, and the court did not buy it. They said that this doesn't apply. This applies to ports, different ports, and you can't use this as a way to try to get out of the application of a waiver if the vessel is coming and going from the same location. So these are very common types of contracts. Particularly, you'll see it in parasailing and in some boat rental activities. There's other laws on the books, specifically like we went through the livery statute, and parasailing has its own set of requirements and laws, but it's something to know. These waivers under Florida law, they are disfavored, but they're upheld. They typically will not be upheld, or actually, I don't think they'll be upheld at all for minors. There's Florida Supreme Court law on that. It's a public policy argument, but it's something important to know and to counsel your client on. If you're defending or helping someone set up a business, or certainly if a plaintiff signs one and tries to bring you a case. So they have to be fairly specific. These waivers need to spell out what people are waiving. There's an argument to be made that you cannot limit liability under a waiver for gross negligence. I cite some of the case law that's controlling there, and it's something to keep in mind. If the fact pattern rises to the level of gross negligence in your tort claim, then there's an argument that the waiver will not apply. Similarly, and this kind of dovetails with the inland navigation rules and some of the negligence per se arguments, a tortfeasor cannot contractually waive liability or have someone waive liability arising from statutory violations. So, if you violate the parasail statute and you're a parasail operator, you can't claim that your waiver is going to preclude liability. The key case on that here in Florida is the Tassinari versus Key West tours. And I've seen it in federal courts broadened to include in North Florida, I believe, the inland navigation rules. So, you can't, it's essentially common sense policy argument. You can't waive compliance with applicable state and federal law. We already touched upon this. This is just the federal provision, which makes it impossible to waive liability between ports in certain circumstances. Next, I want to turn to the Death on the High Seas Act, which we're all probably familiar with if you're doing tort claims of these nature. It's a hard law. I think it certainly makes it a hard conversation when someone has lost a loved one to have to explain why, if this happened here in Miami-Dade County, the amount of damages might be absolutely different than if it occurs, 4 nautical miles out. And it's also a lot of moving parts and a lot of distinctions that I personally need to look up typically every time I'm looking at these cases and make sure I get it right. But we all know that under the Death on the High Seas Act, you can recover for fair compensation for pecuniary loss, which encompasses net accumulations of the estate, medical and funeral expenses, and then your loss of support and services. It's paramount for plaintiff practitioners to explain to your clients, under these cases, you are not going to get the pain and suffering, the emotional damages that we're accustomed to getting on land-based cases. And, you need to know that, but you also need to know some of the distinctions in the law as to when it will apply. And Florida even has some funky nuances that we'll go over as to the application of DOSHA. So when does DOSHA apply? Generally speaking, when the death of an individual is caused by a wrongful act that occurred beyond 3 nautical miles from the shores of the United States, then Death on the High Seas Act will apply. And that's codified there, as you can see, under 46-30302. But it's a little more nuanced than that, particularly here in Florida. So in Florida, we have some differences based upon our boundaries and the Constitution. Florida's Atlantic boundary extends to 3 miles from the coast or to the shoreward edge of the Gulf Stream, whichever is greater. You can find that in Article 2, Section 1 of our Constitution. So the shoreward edge of the Gulf Stream actually runs 7 or more nautical miles from the coast. I want to say it goes as far out as 12, but that don't quote me on that. And in those cases where it's still Florida waters, then the Death on the High Seas Act should not apply, and you should be able to supplement with your Florida death damages, your Florida wrongful death damages, which is going to give you a much more robust claim, obviously, than if you're just dealing with the pecuniary losses. So the site to remember there is Kip versus Amy Slates. It's an interesting case. And then I'm also fairly certain that on the Gulf side that there's a different boundary as well. It's an important thing to consult and consider if you're handling one of these cases involving the potential application of DOSHA. Another interesting point to DOSHA is when does the incident have to happen and where does the incident have to happen, right? So it might be counterintuitive to think that if someone gets hurt or falls ill or something bad happens out at sea and then they fly home to Nebraska and die in a hospital there 3 months later, will Death on the High Seas Act kicked in? And this has been litigated. There was, I think, some uncertainty, but it's pretty clear now that it is the culmination in injury that the law concerns itself with when determining DOSHA's applicability. So it's the place of injury or the place that the accident actually occurs. So again, like I was talking earlier about, maybe you have a jet ski case with the products liability component. If it goes wrong out at sea, that's DOSHA is going to apply. It's not going to matter that the part was made somewhere in middle America. Keep that in mind. And there's the citation to that case. I think it's kind of interesting how this all works and all the moving parts. But most importantly, just remember your DOSHA damages. You're going to have loss of support, services, nurture, training, education, and inheritance. If you have some very young children, you could work that up with an economist, perhaps, funeral expense, net accumulations to the estate. And then in certain nuanced circumstances, just pre-death pain and suffering under the Jones Act for crew members. next common defense and issue that's important to consider is going to be notice. This is probably the most hotly litigated area in the standard or average maritime case. It's critical. I think defense attorneys know the importance of it. The federal judges down here are certainly not shy to dismiss a case if you don't prove notice, and it can be a harsh law, but it also is provable. And I think there's been some good decisions on the plaintiff side over the past few years. The Amy case was sort of a beneficial development. The Yusko case, that could be a lecture all in and of itself, but it's important to know how notice works in these cases. And it's not quite as simple as some of the state court law where you can just show, footmarks or something like that. You kind of have to go a little deeper and really start from the onset in your discovery. And it's an important part of the investigation for everyone. So the owner of a ship in navigable waters owes passengers, like I said, the duty of reasonable care. And then you have to go ahead and prove your traditional elements of negligence. But what I think is more of a key consideration in maritime than it sometimes is on land is the notice requirement. So you have to prove actual or constructive notice. And there's a vast body of case law on this that you should be aware of. And there's cases coming out every few months that sort of change the landscape. Typically speaking, you can establish notice through a warning or taking a corrective action about the condition. So warning signs, obviously, if it existed for a sufficient period of time to invite the corrective measures, that's sometimes harder to get direct evidence on because it seems that the video or witness testimony is hard to acquire to show exactly how long the defective condition has been there. The case law is holding now about 15 to 20 minutes is sufficient. But I wouldn't personally want to rely just on that. If I was bringing a plaintiff case, I'd want to work to get a little more through particularly warnings and also constructive notice through your substantially similar prior incidents. That's if you do the cruise line work, a lot of the discovery and the discovery disputes go into that because it's such a critical element. So, I like to show this photograph here when I'm talking to particularly people that don't do a lot of maritime, because you can see sort of in the center of the photo, this is a step down on a ship and it kind of blends in. It's somewhat camouflaged. And there's this little green thing that you can kind of see hovering where my cursor is. And that's a warning sign. Watch your step. Just affix there right where the nose is, where that step down is. And if not for that, I'm pretty certain I would have lost this case to summary judgment. But it shows you kind of got to dig deep and do your due diligence, try to find evidence of notice. And obviously it's something to be vigorously defended on if you're defending a case. We all basically know this, but subject to joint and several liability, Admiralty law is going to follow a comparative fault regime. I put this in there because I don't believe under the case law that that the changes in Florida House Bill 837 will apply to Admiralty law. For instance, the MedMal, Florida's statutory pre-suit procedures for MedMal have been held not to apply to Admiralty law. So I don't see why HB 837 would to change the comparative fault regime. So I think that's going to stay in place. I don't know if I've seen it litigated yet, but I'm pretty sure there's favorable law so that we'll be clear on both sides that this is what we're going to have in place moving forward. Another important consideration on the boarding of medicals, starting a few years back, there was a deviation somewhat from how Florida trial courts will analyze this under state court law. And the measure of your medical expense damages is going to be a mixture of things in Admiralty cases. So the reasonable value of medical treatment determined by the jury, they'll be able to consider the amount billed by healthcare, the total amount paid, and then any expert testimony on the evidence the parties may offer. That's the Higgs case. There was somewhat of a split before the Higgs case on how this would work in terms of what you could board and what you could show the jury. But now this is the rule that the judges will follow. And I think it's probably the right rule and a fair one, and the jury can get it right. Another special nuance to consider, obviously, most of us know this, is that you can't get your loss of consortium in maritime and Admiralty cases. Something important to know if you're analyzing case value early on and you don't do a lot of this type of stuff. So that more or less wraps up what I wanted to talk about. I hope it was somewhat useful in terms of key points that you probably have to consider regularly, and some new developments in the case law that I think are important. Particularly the one that interests me, if you couldn't tell, is the limitation of liability and how that's changing and how that might change the landscape over the next few years of other laws as society grows and technology grows and we all become more sophisticated. And we'll see what happens. It's an interesting time to be practicing this. So some of the key takeaways, if you're not doing a lot of this or you want to talk to people that are getting into it, make sure they're certain as to exactly what law will apply, not only generally, but on their specific issues. Analyze in detail all those different theories of liability and defenses, because as I stated, there's a lot of creativity to be had in our field. And then, familiarize yourself with the rules of the road. Perhaps you want to consider getting an expert if you're going to do a bigger case that can help you to navigate those. There's a lot of great guys that are former Coast Guard and former FWC, and even people that have literally written the book on maritime law here in Florida that can help you out. I think, like I said when I began, I love this field. I love the people involved. I think we're all a close-knit community. And even if you're on opposite sides, we typically get along and like to see each other learn and grow. So I'm always happy to talk about this stuff. I'm somewhat obsessed with it. If anyone ever has questions or just wants to chat about a case, feel free. And we'll leave it open for questions for the next few minutes. If not, we'll take a break before we have Curtis Mace. I'm excited to hear him speak on a really great topic that he and his firm have a ton of real life, experience handling, is the sexual abuse type cases in the cruise line context. So thank you all so much.